South African representative Anthony van Zantwijk, who is also here, is his partner also of his law firm Z&S. And I'm going to introduce this a little bit later. And this South Africa is a very interesting country because it's the only country until now that has the one patent granted for that artificial inventor project. So this is going to be very interesting to hear from Anthony. And I'm going to try to present a little bit of the position how we do this is in the Andean community law. So please, first, the order is going to be that first, Dr. Ryan Abbott is going to be talking to us. After that, it's going to be Yunjin Choi who's going to be joining us in the discussion. Anthony Van Zantwijk is going to be third, and the last one is going to be myself. I am a partner of L'Arte Mode, and I'm working here in Japan. I'm talking to you from Japan. After every single presentation, if anybody has any questions or they want to address something specific to the panelists, where we will have a small space for one or two questions. If not, you can hold your question until the end. We're going to have plenty of space, I hope, plenty of time, I hope to have a very good discussion and receive all your questions. And I'm sure you are going to have a lot of questions. And based on that, this panel is going to last only for 60 minutes. So until 10 a.m. Colombia, 8 a.m. in LA, and midnight in Japan, we are going to be here together. So thank you very much, all the panelists. Thank you very much for Dr. Ryan Abbott, Anthony, Yunjin, for being here. It's a real pleasure to have you here. So before starting, I would just like to present a small greeting to my friend, Dr. Hiroki Hashimoto, who was intended to be here also, but he's now facing a very complicated challenge for his health. So we are wishing for him very good health and recovery and complete recovery from his illness. So my dear friend, this is a greeting for you. And without further ado, I would like to invite Dr. Ryan Abbott to take the floor and enlighten us with all the things you have done. Before that, let me just read very quickly about Dr. Ryan Abbott. I'm sure many of the attendees know about him, but just let me give you a little bit of introduction of his bio. Dr. Ryan Abbott has a lot of titles, is MD, JD, MTOM, which I'm sure he's going to explain what that is. PhD, is a professor of law and health science at the University of Surrey School of Law, adjunct assistant professor of medicine at the David Geffen School of Medicine at UCLA, partner at Brown, Neary, Smith & Can, LLP, and a mediator and arbitrator with GAMS, Inc. He's the author of The Reasonable Robot, Artificial Intelligence and the Law, published in 2020 by Cambridge University. He has published a lot. He has worked as expert in the United Kingdom Parliament, in the European Commission, the World Health Organization, the World Intellectual Property Organization. He's a licensed physician and a patent attorney in the United States and a solicitor advocate in England and Wales. Managing Intellectual Property magazine named him as one of the 50 most influential people in intellectual property in 2019 and again in 2021. So Dr. Ryan Abbott, it's a pleasure to have you here. Please go ahead.
Well, thank you, Carlos. It's an honor and a pleasure to be here, and thanks everyone for attending, in some cases in unpleasant hours of the day, but hope we're going to have a great discussion. And Carlos, thanks for also reminding me how much student debt I have, but that's okay. Davis is paying me in Bitcoin, so any day now. AI has really started doing some pretty exciting things these days. This is a screenshot from a video of a by a team at Google, which published research in the journal Nature describing an AI using deep reinforcement learning that they had built to automate chip floor planning. Chip floor planning is the process by which components are arranged in a microchip. And how the components are arranged in a microchip affects how the chip functions, everything from how much power a chip uses to how quickly it performs, how much components like wire are needed. So these designs have a lot of value to companies like Intel that make microchips. The team notes that it is traditionally a labor-intensive process to make one of these designs. It takes multidisciplinary teams of people months to make a new chip. They claim their AI can make one in under 6 hours, and that the AI design chip outperforms the human design chip on all the key performance indicators. And whether this is an example of AI invention or not, what you have is AI increasingly improving in capability and industry adoption, and starting to automate some aspects of R&D. And as AI continues to improve, this phenomenon is only going to grow in scope and importance. A few years ago, there was really very little law about what would happen if you had an AI invent something. And so I led a team of patent attorneys, including Eric Van de Veyer, who's also on the phone, and Von Seidels, which represented us in South Africa, in filing patent applications internationally for 2 AI-generated inventions. One was for a flashing light that could attract attention in an emergency, and one was for a beverage container design based on fractal geometry. We filed these in the UK and in Europe first because they underwent substantive preliminary examination. They both passed UK substantive preliminary examination, and then we corrected inventorship and noted that the AI was the inventor, and we listed the owner of the AI as the applicant. So we listed the AI as the inventor for a few reasons. First, it was factually the inventor, so we listed it legally as the inventor. The presumption was that in every jurisdiction you need an inventor, although some jurisdictions like Austria and Israel do not require an inventor to be listed. And a couple jurisdictions like Cyprus and Monaco, which are EPO member states, have reported that they don't require an inventor to be a natural person, presumably allowing corporate inventorship. This wasn't a matter, however, of granting the machine any rights or ownership. Most patents aren't owned by inventors. Most patents are owned by employer inventors. And so most patents are owned by artificial persons in the form of companies. So the AI was simply listed because it was factually accurate, transparent, and would facilitate chain of title. We argue that the owner of the AI should be the owner of the patent applications. And while there isn't a statute anywhere in the world that says that's the outcome, it is grounded on common law rules of property ownership, including a Roman doctrine referred to as accession, which basically says, if I own property that makes property, I own that property. I own a lemon tree at my house. I own the lemons from that tree. I don't require the tree to execute a written assignment document in my favor. If I own a 3D printer that makes a beverage container, I'd own that physical object. So if I own a computer that makes a digital artwork or a new method of painting, the same principle should apply there. So we filed these applications explicitly as test cases to promote a dialogue on what rules we should have for AI and IP, to provide guidance for stakeholders, particularly those in drug discovery and repurposing and materials engineering, where uses of AI like this were prevalent, and to promote the view that this is the sort of thing we ought to protect. Historically, some people have thought, well, if an AI invents something, you don't need to protect it because the AI doesn't care about a patent. And that's certainly true, but also a straw man argument. It is not the AI that cares about the patent. It is the person who owns the AI that cares about the patent. And if we want, for example, drug companies, the next time a COVID virus comes along, to go to a bunch of supercomputers to find a new antibody to treat it instead of a room full of pharmacologists, this is an activity we need to encourage to promote innovation, disclosing trade secrets, and commercializing new inventions in the form of products. In July last year, South Africa granted a patent with Dabis listed as the inventor and with Dabis's owner as the owner of the patent. South Africa, as many of you will know better than I, doesn't do substantive examination, but they do formalities examination. And everywhere the patents have been rejected, it had been on a formalities basis. The patents already went preliminary substantive examination in the UK successfully, for example. 3 days later, the enlightened Justice Beach in the Federal Court of Australia ruled that an AI could be an inventor on a patent, and at least in our case, the AI's owner had the best claim of entitlement. Justice Beach's decision was overturned by a full panel of the Federal Court of Australia a few months ago, but the Australian High Court has just agreed to hear oral arguments on whether or not to accept an appeal from that. In the UK, the Court of Appeal split. Justice Burst thought that we should have gotten a patent. Justices Arnold and Lang thought that we shouldn't. All the justices thought that an inventor had to be a natural person, but Justice Burst thought as long as you designated who you truly believed to be an inventor, that was sufficient, and the patent office should not be invalidating patents. The UK Supreme Court has recently granted special leave to hear the case, so oral arguments before the UK Supreme Court are set for February. The Court of Appeals for the Federal Circuit in the US, which is the federal appellate court, recently rejected the application on the basis that an inventor has to be a natural person, and that puts an end to the matter. The law is different in the US and the UK, for example, and in other jurisdictions. In the UK, for example, an inventor is the actual deviser of an invention, never says it's a natural person. And in addition to owning an invention by being an inventor, in preference to an inventor, the employer is entitled to the invention, or someone who has superior claim by virtue of any rule of law. So that would include common law rules. The US law seems a bit more closed, but even there, inventors are defined as individuals, which the US Supreme Court has said sometimes is a natural person and sometimes it isn't. And there are prohibitions in US law on prohibiting inventions based on how they are made, which here would include, in our view, an invention being made by an AI. The European Board of Appeals in December rejected the case, but noted that there was no reason why, under European patent law, the user or the owner of an AI couldn't designate himself as an inventor, and that one could even write in the specification that something was AI generated. So we have filed a divisional in the case, designating the owner of the AI as the inventor now on the basis that he owned an inventive machine, and presumably a patent will issue on that basis. The German Intermediate Federal Court determined that, or stated that, Germany doesn't have US, UK-like inventorship rules. So for the court, the person with the closest nexus to the invention is all that's needed to designate as an inventor. And if one wants to, they can designate that an invention is AI generated in the specification of an application. The German Patent Office didn't like that outcome and is now appealing that case to the Supreme Court. 10 minutes isn't a lot of time. I think there's a lot of interesting stuff, which I'm sure we'll get to here. But it's also interesting, again, that today AI is doing some impressive work in a couple of sub-industries. 10, 20 years from now, I expect AI is going to be doing a whole lot more, and not just automating certain aspects of research and discovery, but probably transforming certain aspects of research and discovery, because in some areas, AI has the potential for vast improvements over human researchers. Particularly, again, I have a biotech background in drug discovery. So I think that this is something that's going to be tremendously socially beneficial, and that we need the right rules in place to deal with. And I'll stop there.
Thank you very much, Dr. Abbott. I think there is a lot to chew here, and I hope we are going to have the time to do that. So without further ado, I would like to introduce Ms. Yunjin Choi. She is Senior Manager, Director of International Division and Patent Attorney, specialized in physics and material science at Shiga International Patent Office in Japan. She has a master's degree in the Department of Physics in the Seoul National University. Ms. Choi is qualified to represent parties in court in IP infringement litigation. She specializes in near-field optics. She has experience in research and development of polymer organic EL displays and patent prosecution in the field of semiconductors, optical devices, magnetic devices, industrial machinery, and mechanical devices. So Shiga International Patent Office is one of the largest intellectual property firms in Japan, and they represent around many startups and Fortune 500 companies in filing applications at the Japanese Patent Office worldwide. And just, I think, recently they were just named among the patent office that the patent law firms in Japan has they filed the most patent application in the world. So Yunjin, welcome to this panel. Thank you very much for being here, and we are all ears for you.
Okay, thank you, Carlos. Okay, hi everyone. Nice to meet you. I'm Yunjin Choi from Shiga International Patent Office in Japan. I would like to talk about the artificial inventor innovation and IP law in Japan. I would like to start with a review on application trends in Japan. The upper graph shows the total number of JP applications, and the lower graph shows applications AI-related inventions. Recent years, the total number of JP applications is decreasing. However, applications of AI-related inventions increasing since 2014, and actually is in the middle of second wave. In 2019, there were about 5,000 applications for AI-related inventions, and there are about 2,000 applications belonging to classification G06N. G06N is a patent classification given to inventions related to computer systems based on specific calculation models, and mainly indicates AI technologies. Please note that both numbers, applications for AI-related inventions and applications belonging to G06N are increasing since 2014. This slide shows the trends of applications belonging to G06N. In all countries, including in Asia, the number of applications of G06N is increasing. Especially in 2018, China surpassed the United States. In addition, the number of applications of G06N in South Korea increased at a higher rate, exceeding Japan and Europe. Under this situation, IP protection for AI-powered inventions is becoming important. It can promote development of AI, inventive AI, and ultimately generate more innovation for society. If products created by AI are not protected, free ride will happen in spite huge capital is invested, and actually in some cases, AI itself becomes economically valuable. In the worst case, a third party will use AI to avoid infringement. Eventually, company will be reluctant to invent AI and to file AI-related applications. From now, I'd like to talk about current states of IP law and practice in Japan. First, I'd like to review how premised inventions of works created by AI are protected. Machine learning is the main premises of works created by AI, and machine learning consists of three parts: training data, program for training, and trained model. This slide shows how they can be protected by IP laws in Japan. First, training data can be protected by unfair competition prevention law as trade secrets if they keep secret, useful information, and not publicly known. And also they can be protected by copyright law as a database if they are systematically structured that is easy to search, and creativity is recognized in the structure. However, it is deemed not to protected by patent law because of not usually advanced idea by using the law of nature. Second, program for training can be protected by all of them because program itself can be protected by copyright law, and the algorithm in the contents of program is protected as an invention of a product. However, trained model is deemed not protected by copyright law because a list of numbers that is automatically output in the forms of numbers, matrices, parameters, etc., is considered having no originality as a copyrighted work. And also, it cannot be protected by patent law because function of the program itself is not recognized as an invention. Inventions created by AI are of two types. The first type is an invention invented by using AI as a tool, and human creates substantial technical ideas. In this case, human is evaluated as an inventor and can receive a patent. Second type is an invention created autonomously by AI, and there is no human involvement. At the current level of AI technology, it is difficult to imagine AI creates autonomously, but actually it cannot be said certainly that autonomous AI creations do not exist because we don't need to disclose the involvement of AI in the specification. Copyrighted works created by AI are of two types. Similarly, please note, copyright law requires humans' involvement in creative process to be recognized as a copyrighted work. First type is work by using AI as a tool and human creatively involved in expressing an idea or emotion. In this case, produced content becomes copyrighted work and it belongs to the human. The second type is created autonomously by AI, and there is no human involvement in creative process. Work of second type does not constitute copyrighted work and not generate a copyright. Regarding what an inventor is, actually, there is no clear stipulation in Japan's patent law. However, Japan's patent law requires name of the inventor in the application. So it is interpreted that inventors are limited to natural person. In addition, last year, JPO clearly announced inventors are limited to natural persons. So a patent application in which AI is written as an inventor is not acceptable in Japan, and it will be dismissed if appropriate correction is not made. Let's review the possibility on whether rules for employees' inventions and employees' works can apply to AI-powered inventions or AI-powered contents. Regarding inventors for employees' inventions, only employees can become inventors, even for employees' inventions. And these employees is deemed to limited to natural human. So regarding an inventor, Japanese patent law adheres to natural person only. On the other hand, right to obtain a patent shall originally belong to company if stipulated in company's regulation. Thus, under the current situation, current Japanese patent law, rules for employees' inventions cannot apply to AI-powered inventions. However, regarding rules for employees' works, company can become an author as well as copyright holder. Therefore, there is room that rules for employees' works can apply to AI-powered content. This slide shows what sort of alternatives are available. As I mentioned, content created autonomously by AI is not protected by copyright law, but Japanese government IP strategic program 2016 clarified that those contents created autonomously by AI can be protected under unfair competition prevention law if they come out into the world and become known to many people and have a property value as a result. It also clarified that registered trademarks can be protected under trademark law. Currently, we have only few alternatives, but through deep discussion continuously, we hope that further alternatives can be prepared. Thank you for your attention.
Thank you very much, Yunjin, for your presentation. I want to remind everybody that if you have any questions for any panelists, please use the QA questions box or the QA box or the chat. And I will be happy to convey all of your questions to the panelists. Next, we have our representative from South Africa, who is going to be very interesting, as Dr. Ryan mentioned. It's the only country that has gotten a patent. Anthony van Zantwijk is a partner of Sibanda and Zantwijk. Patent attorneys partner and Zantwijk is a top patent filer in South Africa. He is a patent attorney and a registered tax practitioner. He has a Bachelor of Science in Civil Engineer, LLB cum laude, and LLM in tax from Wits University in Johannesburg, South Africa. He focused mostly in commercialization, IP commercialization, tax, transfer pricing, and valuation, and have been engaged as an expert witness in 4 IP transfer pricing valuation court cases. So, Anthony, thank you very much for being with us today. We are looking forward to hearing from you because I think you are very, very interesting story to tell about. So please go ahead.
Well, thank you. Just to make sure everything is showing, right, on the screen?
Yes.
Well, thanks, Carlos. So yes, South Africa did grant the patent for AI. This is the register page. It's quite clear. The inventor is Davis. It was filed as with the inventor being Davis. South Africa doesn't conduct substantive examination, but this kind of thing does get covered in formal examination. So you do have people at the patent office who check inventorship, follow that the applicant or the forms are correct, the assignment, the chain of title from the inventor to the applicant should be there in the file. Clearly it got accepted, it therefore got granted. It is a valid patent in South Africa. I understand that when this was filed in South Africa, it came from the PST, of course, and that no separate assignment document was submitted to the South African Patent Office. No assignment document, I understand, was also submitted to the PST office. That may have resulted in a bit of an oversight by the South African Patent Office because quite a few things, if it flows from a PST, let's say priority documents and translations of them, are not required in South Africa if you flow from a PST. It shouldn't have necessarily gone through unnoticed. I don't know if it went through necessarily unnoticed, if there wasn't an assignment document. The bottom line is that it was accepted. And I don't think it's necessarily wrong that it was accepted, despite what a lot of articles are saying. Let's just have a quick view of what an inventor is in South Africa. It is quite clear that there's very little that talks about inventor in the South African Patents Act. It always refers to the inventor as a him or a he. It also talks about a person when it talks about an applicant. And so there are two concepts. There's the inventor concept, where it only refers to him, he, and there's a person concept, which is definitely quite a bit broader. Now, in terms, so of course, if it refers to he, it refers to her too, but still it's individuals. So on the face of it, an inventor has to be an individual. A person, on the other hand, is definitely quite a bit broader. So we have the Interpretation Act, which brings persons, may include companies. That's kind of universal. In property law, persons basically anyone who can accept rights and obligations. Certain acts can expand on the definition of person. So our Income Tax Act includes trusts and various other things as persons, but the Patents Act doesn't expand. So the Patent Act really is limiting persons, if it refers to person, to individuals and to companies and some body corporates. It's the reason why we're talking about person, because later on we'll see there may actually be some kind of an alignment between inventor and person if one looks at a conflict in the act. But right now, just for the purpose now, you've got AI is clearly not a person. It's not a company. It's not an individual. It's none of those other entities that by Interpretation Act, the definition of person is extended to. Inventor on the face of it is a little subset within the person definition. So AI needs to somehow find its way from outside the person circle into the inventor circle, or we need to grow the definition of the inventor circle. In our law, so that's the first thing. Who is the inventor that we're going to cite? Because our patents do require the inventor to be cited. The next thing is that the Patent Office has to have a look for a chain of title from the inventor to the applicant. And we can submit any proof of assignment. So if you can show the person was employed and was in the course and scope of his employment, that is good enough. Any kind of proof, it doesn't necessarily have to be a signed deed of assignment document, or that is, of course, the most common. As I say here, no assignment seems to have been submitted, but there may be another way to actually assign it from the inventor, in this case, to the applicant without requiring any of this. And that's under Roman law. So South African law comes from the Roman law. Roman law went into Netherlands. Netherlands law came into South Africa. Of course, Napoleon took over Netherlands, and that did away with the old Roman Dutch law. But South Africa kept its Roman Dutch law. And if there's a gap in South African law, one always looks back at Roman law. Now, I was very fortunate in 2018, going through a little bookshop in Charing Cross, and there was a Institute of Justinians. Now, Justinian's Institute was basically the textbook for anyone who was studying law in Roman times. And Justinian, that's basically 530 AD. And it consolidated all of Roman law. So it really is a great foundation. If there's a principle in there, it actually applies in South Africa if there is a gap in South African law. And let's just forget about property. Yes, property law, there is a concept there of fruit, which we're going to discuss. But there's another concept of, what about the slave? I'm not talking about a slave necessarily in today's context. In Roman law, in those days, slaves were considered pure property. I, as the owner of the slave created. But the slave could not own anything. The slave didn't have any rights. Initially in Roman law, I could even kill a slave if I wanted, and there'll be nothing wrong with that. But then the emperor felt sympathy and said, actually, you're not allowed to do that. But basically, a slave had no rights, could not own property, wasn't considered in the legal definition under property law of a person. But he could create. And isn't that very similar to what a computer is? A computer is someone owns it, it's property. It can create, it can't own. No one recognizes it as it can acquire rights. It certainly can't assign. All of that a slave also could not do. So the thing about Roman law, of course, because slaves are so important, they had a lot of legal concepts regarding slaves. And we'll have a look at a few of those. The first thing was that a slave, these are extracts from Justinian's Institute, slaves could not own. So the original owner was always the owner of the slave, the owner of whatever the slave developed. It did not go toward, did not discuss who trained the slave. It did not discuss anything about feeding or anything. It is purely who owned the slave. There were some other paragraphs there where there would be someone who maybe leased a slave for a while. Let's think that you put on your AI is on the cloud. The cloud may be owned by Amazon. So if you're just looking at the narrow concept of ownership, could Amazon potentially be owning a lot of things where the AI is actually computed on the cloud? Also in Roman law, they actually went further from pure ownership, and they said if a slave gets leased out. So someone has a usufruct, basically lease rights over the slave, and the slave makes something while he's being leased out. The lessee is the owner of that slave's creation. So let's go back to the Amazon. I may be then leasing some access to the cloud. The AI is on the cloud. Even the computing power may all be on the cloud. But as long as I've leased out the use of that, I, under Roman law concepts, because I've leased it out, if that creates something, I am the original owner. Now, in Roman law, therefore, when a slave actually created, no one said this was made by the slave. Any kind of ownership, everything was linked back to the owner. And so if you had a lot of pillars, a lot of stones, you'd have the name of who created on the stone to kind of show its origin. It was always the owner, despite the slave having maybe created it. So the slave was never really recognized there either. The slave was just seen as the owner, as having created something on behalf of the owner. So I think that despite the ownership, which is another good argument, the slave concept, because it's so analogous, is actually a computer akin to pure property of who the lessee or the owner is. So this was the little book, 1985 or something. Let's have a look at the concept of original ownership. So yes, we've got accession. If land accretes to someone's island, then you own that. But there's really the concept of fruit. So if you have a principle and the principle then creates something, and a computer, like Ryan Abbott said, a computer creates the invention, that is a fruit of the computer. And I think that that's quite clear. And in Justinian's Institutes, it actually says that is by some natural law. It didn't even say common law. Justinian does actually refer to common law in the Institutes, but he said by some concept of natural law, which it's even greater, most probably, more ubiquitous than common law. He says that the owner of the principle is the owner of the fruit. And so if you look at that, then yes, you could also apply the original ownership is the owner. The problem here, and also Roman law also deals with usufruct. If I'm leasing that principle, I again become the original owner. So I think on two grounds, Roman law is really good, except I do believe that it is quite, and there's more rules when it comes to pure slave law. Let's just have a quick look then at the ownership. So yes, we need to have the chain of title transferred, but what if therefore the owner is a company? Because inventor, if that's limited to a natural person, we may have a problem with the natural person being regarded, or the owner being regarded, company, being regarded as the original, as the inventor. Well, in our regulations, we do have where the concept of inventor is linked to the concept of a person. So the regulations, the forms that get signed, it's not in the act, and that equates person with inventor. First time it actually does this. And remember, person has got a broader definition than inventor. And there's general kind of interpretation of statutes. Says if there's a conflict in an act, though, one must read the conflict to kind of make sense of it. And therefore, we want to expand the concept, the definition of inventor, to the same scope as a definition of person, which would mean that inventor could therefore be a company, if the company was the owner or the lessee of the AI. However, the only problem here is that the conflict comes from the regulations. So the conflict doesn't come only within the act. And so maybe these principles don't necessarily apply. But so we're first moving from the inventor is maybe not just the AI. It could be someone who owned or leased the AI. Then the inventor could even be a company if the inventor can be regarded as a person. So scope, the definition the same. And but that does take a little step further than purely using the Roman law for the first step. Thank you.
Thank you very much, Anthony. Very provoking, and I think we have also discussed later on. Just to start a conversation, Dr. Abbott, I've been reading some of the documents, for instance, of all the discussion with the Federal Circuit in the United States. And recently you have been focused on the meaning of individual. What individual means, and why is that important, and why it has to be something that you have to discuss at that such level. After the call of the Federal Circuit actually refused to grant a patent and also to recognize an AI as inventor. Why the name individual has any meaning or has any sense in the US, on the US law. That's the first thing. And the second thing is I wonder about why do we need patents? Based on what I have seen in many inventions in AI, they tend to use more trade secrets than patents now. So why patents? Why not keep it in trade secrets? So let's start with this couple of questions, Dr. Abbott.
Sure, great questions. The second one I think is easier, so I'll start with that one. Sometimes applicants use trade secrets, sometimes applicants use patents, sometimes you combine the two, but it's really very fact specific based on what the invention is. So for example, if your invention is a new computer implemented invention or AI implemented invention where AI is transforming some input into output, and that is your inventive process. That's the sort of thing that a company might be able to successfully maintain on AWS behind a firewall, and no one will ever see the AI training data or training weights, and you can keep it protected for a long time. In our case, you had an AI make two physical devices, and the minute one of those was sold commercially, it could be reverse engineered. So for some things, trade secrets work, and for others, they don't. And, very industry and invention specific. The other question I thought was very interesting, and both of the other panelists gave really insightful, interesting presentations, which I appreciate. And, Anthony's was particularly of interest to me it was largely about Roman law, but I was particularly interested I got to walk by Charing Cross in some of those insights into Roman law. And, it made me think a couple of things. I mean, first, that my Roman law colleagues in university tell me that Romans really thought about everything legally, and that if we just do what they did, we'd all be fine. So they were pretty insightful. They are kind of getting at fundamental principles of property ownership. Not that I'd quite call them natural law, but, the principles on which a society should organize itself about property. And it's interesting how applicable those principles are today. And also that it's strange to me that some courts have wanted to get so very textualist on statutes that clearly were not written to deal with this new technological phenomenon, instead of resorting to a purposive analysis. But in the US, courts have gone very textualist. And so the Federal Court of Appeals, for example, while it asked the patent office, is the outcome of all this that you don't get a patent? And they said yes. That's about as far as they wanted to take it. And they really never even dealt with that in the opinion. To them, the statute says what it says, and that's the end of it. Which is, one way of resolving issues. The problem is, statutes are so very rarely just what they say. An individual is a good example. So the case entirely turned on the definition of individual. And you saw in Anthony's presentation that the Oxford English Dictionary says, it's a person. But the second sense in the Oxford English Dictionary is a thing. So, and sense order is not relevant in dictionaries to more correct or common, it's chronological. So when we filed our en banc petition last week, we noted actually these dictionaries that you're citing against us, if you go one sense down, it says a thing, and RAI is literally an individual by the dictionary definition. So, even things that seem clear, an individual means this, the dictionary says it means this, aren't necessarily so clear. And to me, the only sensible way to resolve these issues is to think, why do we have patents? What's the problem we're trying to solve? How does it best work here, right? And here, our argument is this sort of innovation is just as socially worthy of protection as any other sort of protection. I'll just say one more brief thing, but different jurisdictions have different policy bases for their law. For example, Yunjin spoke a bit about copyright law. In the US, the Supreme Court has been very clear. We have copyright law to generate and disseminate works. And if it happens to do useful things for other people, so be it, but it's economic. In France, they have a very different view, which is it's there to protect authors, often from big evil corporations. And you would never protect something made by an AI. It doesn't matter how wonderful it is. We don't want more stuff. We want to develop human authors.
Thank you, Dr. Ryan. I'm thinking about we have so many inventions, and it's happening right now based on AI or using AI or coming from AI. I'm thinking about the inventive step obviously in the United States. That's going to change. It's going to change who is going to be the level of the person or the average skill of art. That's going to change because it's going to be a lot faster, a lot easier, a lot more complicated, more complicated for humans to actually get to that level. Computers can do faster and get more information and get more associations than humans do. So I wonder if that's going to change, or what do you think? How is going to change this requirement for patent law? Because in the European in the APC, for instance, the Board of Appeals was saying, okay, I can give you the patent, and I will give you the patent, and it has novelty, inventive step, and utility, industrial application. And it's okay. I will give you the patent as long as you just name somebody as the inventor, and the inventor said, you know what, I am the owner of the machine, or I am the engineer who trained the machine, or the user of the machine. It's okay. But then we're going to jump to this other level, which is going to be inventive step. The inventive step is going to be more complicated because then it's going to be more obvious or less easy. And inventive step already is very, very, very complicated requirement to meet. So that's going to change in your vision. Is going to happen like that, or we're going to be so far the same thing?
Sure. No, another great question. If that one's for me. Well, I think two things about this. Sorry. AI inventorship, to me, AI inventorship and inventive step are totally separate concepts, because the inventive step analysis in the US, for example, is explicitly based on what an average researcher would find obvious, not what an inventor would find obvious. Because inventors are supposed to be exceptional, so inventors would find almost everything obvious. So whether or not an AI could legally be an inventor, that explicitly is not part of our test. But I do agree that the skilled person is supposed to represent an average hypothetical worker, and they are already often augmented by AI today. That's something that European jurisprudence has, helped evolve. The skilled person is now a skilled team of people in some industries where team-based approaches to research are the norm. And I think it should already be, a group of skilled average researchers using AI, because AI makes it so that more art should be analogous art, because the AI can give you access to really prior art anywhere, even if a person trained in chemistry wasn't trained in physics. And it makes average researchers more knowledgeable because it can help them with problem solving techniques that they couldn't do alone, like pattern recognition and big data sets. And to me, the question that's relevant is, is this use of AI the standard way that problems are solved in a field? And if so, it becomes part of the skilled person standard. Now, at some point, as AI hopefully gets so incredibly good that it changes the way R&D is done in industries, and instead of going to rooms of people, you go to supercomputers to solve problems in some fields, then I think the standard really should be based on, what would a person using an inventive AI find obvious, or what would an inventive AI be obvious? And it's difficult because it's a subjective test, and we might have to think about some ways to make the test more objective, like using secondary indica of obviousness.
I wonder if Yunjin or Anthony has something to say about this specific thing. I know you are patent attorneys. So what do you think? Particularly in Yunjin, for instance, I know in Japan, I live in Japan. This is the country of robots. There are robots for almost everything, and actually, the Japanese government is having, I think, kind of a policy. We are having less people, so let's create more robots to do many more things, each time more complicated and more complex. So this is changing how Japan life is in every single day. We are going to have more robots doing more complicated things. So what do you think about the inventing step in Japan? How much is going to be?
Inventive step is also important, but in some cases, for example, chemistry or pharmaceutical cases, even though AI is involved in the application, but some applicants do not disclose because to avoid indication of failure to satisfy enablement requirement, support requirement. Actually, if we use AI, the technical skill will be advanced. So I think it would be advantageous to satisfy inventive step. But as I mentioned, if we disclose AI is involved in the application, some specific enablement requirement or support requirement are necessary to satisfy it.
Thank you very much.
From my side, and I never thought about it, but actually it's really interesting because we're kind of freezing the tests of inventiveness by saying in our case, an expert in the field is a natural person. And so we're testing the kind of basis we're freezing the way that it's being tested. But the actual inventiveness as AI becomes more complicated, becomes more complex, the test should maybe be following with the complexity, just like the average person for inventiveness. If your general, if your experts in the field became more complex, the hurdle for inventiveness would normally go up. But here, as the experts, the natural person experts in the field are remaining static and not becoming more complex, but the machines that are doing the inventive are becoming more complex. You've got a static test for a dynamic inventiveness. And maybe your inventiveness test for AI should be your expert AI, or in this case, to make it dynamic also. It's interesting, I never thought about it.
Well, I have another final question just for the whole panel, because I want to keep it on the time, is this situation reminds me a little bit of Diamond versus Chakrabarty in the United States, the decision in the 1980s, where this decision from the Supreme Court of the United States kind of was the starting point from the biotech revolution everywhere, particularly the United States. That creates lots of invention, force, a lot of investment, and well, it grew up a lot through the following days. And I was wondering, for all the panelists, what do you think about that? Now that we have AI, and AI is a new frontier, and AI as an inventor, and the possibility of having inventors as AI creating, and is already having a very strong impact. So having this protecting AI as an inventor and the capacity for an AI to create inventions probably is going to create a new dimension, in my opinion, a new revolution, perhaps. So if that's the case, South Africa is going to be probably the hub of innovation in AI, because that's the first place where we have a patent. And all the jurisdictions where that's going to be rejected are going to become less attractive for investment and developing AI in research and development and companies and products and so on. What do you think? And I have a presentation regarding that in Latin America, but we didn't have time to do it. But I would like to hear from you, Dr. Abbott. What do you think?
Yeah, well, I mean, I will say that the head of IP for Siemens, Beat Weibel, will say when he's talking about this, that if jurisdictions are not going to protect this sort of thing, they're going to have to move their operations elsewhere, right? And I don't run the IP department at a multinational company, but I will say that I think the rules that one jurisdiction adopts around this sort of thing are a vital component of industrial policy. And there's a race on to win the AI arms race. And if you have AI friendly or unfriendly rules, that's going to impact, how industry develops in your jurisdiction. For my part, I think 20 years from now, it will seem strange that there was ever a question that we, should protect these sorts of things. Although there are many solutions to protecting them that make the industrial strategy work out.
Okay. Anthony, what do you think?
Carlos, I think that's another fascinating point. I mean, if South Africa is the only country whereby by common law, by law, the AI ownership clearly vests in the owner or in the lessee in this case, and it's the only country where that's absolutely clear. I mean, you see, if people are subject to South African jurisdiction inventing here, it would be a better place to invent, because you would use a South African transfer in your other jurisdictions, because this is where it happened and this is a law that applied to it. Whereas if you did it in, say, another country that didn't have regard to Roman law, and you couldn't even refer to Roman law because it's totally not relevant to the context. So look, if the AI invention comes to South Africa, that's wonderful.
Yunjin, what do you think about it? Because Japan, is a champion from robots, AI, research and development. China is just next to us. Korea is next to us, working very strongly, very hard. And Japan is having hard time sometimes to keep the research and development here in the country. It's doing somewhere else, not in Japan. And you show it in the decline number of patent applications in Japan. So what do you think is going to happen if the Japanese government decides that it is going to refuse to recognize AI as an inventor?
As I mentioned, if a patent application in which inventor AI is written as an inventor will be refused. So in the current Japanese patent system, the PCT, Japanese national phase of PCT application of DAVAS will be rejected. So, and as I reviewed regarding whether rules for employees' inventions can apply to AI-powered inventions, as I mentioned, Japanese patent law adheres to natural person only for inventors. So in this situation, it is very difficult situation. But I think possible option is rules for employees' inventions. So some analysis or interpretation should be changed to accept application in which AI is an inventor.
Okay, thank you very much. I have like 400 questions more here for you guys, but unfortunately the time is right now, and I don't want to take you more time, particularly Ms. Yunjin, who's it's midnight here in Japan, so yeah. I'm sure she would like to have some rest. I would like to thank Yunjin, Dr. Ryan Abbott, Anthony, for joining us today. Thank you very much for your time. Thank you very much for your insightful comments and presentations. It was very nice to have you here, and I really hope we will have the opportunity to do it again some other time later on, because this topic, as Dr. Abbott mentioned before, is of the interest of everybody, and I think there is no patent owner in the world and no company who is not thinking about this. So thank you so much to you. Good night to Yunjin. Good morning to Dr. Abbott, and good afternoon to Anthony. Thank you very much to all of you.
Okay, thank you.
Thank you so much.
Take care. Bye-bye. Thank you for everybody to participate. Good night and bye-bye.
Bye-bye.